Hi, I'm Wade Laszlo, steward for Minnesota Public Employees Association down at the Hennepin County Jail, and I'd like to speak to you about some of your rights and your privileges as a MNPEA member. I'm doing this especially in light of the Stanek administration's latest new policy stating that you cannot have a union steward present with you in internal affairs unless you are the focus of the interview. I firmly believe that this is a violation of the contract and of law. First thing I'd like to address is the contract. The contract language is very clear. Article 34, Discipline and Discharge, Section 3. Employees will not be questioned concerning an administrative investigation of disciplinary action unless the employee has been given an opportunity to have a union representative present at such questioning. For my 21 years of employment, we have always been allowed to have a union steward present with us at internal affairs. It is not only the contract, it is a past practice. This is further backed up by a United States Supreme Court decision which gives you what is known as your Weingarten rights. This stems from a decision in 1975 by the National Labor Relations Board that employees have a right to union representation at investigatory interviews. The United States Supreme Court laid down 3 general rules for this. Number 1, the employee must make a clear request for union representation before or during the interview. The employee cannot be punished for making such a request. Rule number 2, after the employee makes the request, the employer has 3 choices, 3 options. A, the employer must grant the request and delay the questioning until the union representative arrives. B, they can deny the request and end the interview immediately. Or C, they can give the employee a chance of having the interview without representation or ending the interview. Rule number 3, if the employer denies the request of union representation and continues to ask questions, it commits an unfair labor practice and the employee has a right to refuse to answer. The employer may not discipline the employee for such a refusal. Now, in light of that, I'd like to give you some practical advice. You get called to internal affairs, you go down for your scheduled interview. You ask the simple question: might this interview lead to my discipline? If the answer is yes, you're clearly entitled to a union steward. Most likely they're going to say no, 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 you're only the witness. Now, as you know and I know, the statement once given could change. For instance, it is legal for investigators to lie to you during an interview. What's to keep them from lying and telling you that you're not the focus when you are? Number 2, maybe you're not the focus. Partway through the interview, something that you say suddenly changes and you suddenly are a focus of the investigation. Or the next possibility is that somebody being interviewed after you regarding the same event makes a statement that suddenly makes you the focus and you've now got a statement out there without protection. I'm not going to advise you to refuse to talk. What I'm going to advise you to do is this. When you get to internal affairs, simply say, can this lead to discipline? No matter what they tell you, request a union steward. If your request is denied, go into the interview. Once the tape is on, state on the tape that you requested union representation and were denied. Then fully cooperate with the investigation, and immediately upon the ending of the investigation, find a union steward and file a grievance. One last thing on Weingarten. This is typically known as the Weingarten card. This is pretty much the statement you give an employer. And it goes like this: if this discussion could in any way lead to my being disciplined or terminated or affect my personal working condition, I respectfully request that my union representative, officer, or steward be present at this meeting. Until my representative arrives, I choose not to participate in this discussion. That's pretty much the law. But as we said, the Stanek administration seems to think differently on this one. The next thing I'd like to discuss are your Garrity rights. Now, Garrity rights protect public employees from being compelled to incriminate themselves during an investigatory interview with their employer. If you're brought into internal affairs or any kind of interview with the employer, request Garrity rights. Generally, they will have you sign a Garrity statement, but I've seen them try to slide out of that sometimes. If they won't give you a Garrity statement, that means that your statement could possibly be used against you criminally, in which case you have the right to invoke your Fifth Amendment and remain silent. Now, these Garrity statements can be used against you in discipline, but they cannot be used against you. They cannot legally be used against you in a criminal case, but they can be used for disciplinary purposes up to and including termination. Another thing that you need to be aware of is your Tennesen warning notice. In our sheriff's office, the Garrity and Tennesen are on the same sheet. What the Tennesen does, it lets you know that the government is collecting private and confidential data from you, and they're supposed to let you know who can receive this information. Generally, it's the courts and things like that, but you have a right to know who has access to this information. Finally, I'd like to discuss something that is very, very important. That is critical incidents. All right? A critical incident could be a death in the jail, it could be a use of force incident, it could be a suicide attempt. When there's a critical incident, generally it's an emotionally charged situation. This is very, very important. Do not make a statement until you've called and spoke to our attorney. Okay? Here's a hint. If they bring detectives down to interview you, it's a critical incident. So before you give a statement, call the MNPEA legal defense line. That number is 651-287-8883. 651-287-8883. Do not make a statement until you've spoken to them and until an attorney arrives. By law, they have to give you a reasonable amount of time. We had a critical incident just recently. I called Mr. Fowler. He answered on the first ring and stated he could be down there within 2 hours. MNPEA is not like our previous representative. You will have that help. You will have that backing when you need it. I just wanted you to be aware of these rights, and it's good to refresh these things. And once again, I'm Wade Laszlo, steward for the Minnesota Public Employees Association. Thank you.